Okay, welcome back to the part 2 of legal language series of videos for the first year BA LLB students. In this video, I'm covering the same topics that I covered earlier in part 1, but these are more in detail per topic wise. So, what is the meaning of law? As I said in the earlier video, the first video, we as law students need to know what law is because that is the basic of our subject of our syllabus, legal language law. Law refers to a system of rules, principles, norms established and enforced by recognized authority such as the government to regulate human conduct and maintain order in society. It serves several purposes, that is, protecting individual rights and freedoms, resolving disputes between individuals or entities, ensuring justice, fairness, and accountability, providing a framework for governance and societal functions. Laws are codified in statutes. So basically, I'm going to read through first, then I'll go through this once again to understand in more depth as to what this particular topic means. What can we understand from this topic? So, laws are codified, they are in codes, in statutes, regulations, and judicial decisions, and are binding on all members of society. For example, the Indian Penal Code IPC defines criminal offences and their punishments, while the Constitution of India establishes fundamental rights and duties. So, this is what we understand. This is a very important question. All right, let's understand what is law. So, law refers to a system of rules, principles, norms established, that is, created and enforced, put into force, implemented by a government or any recognized authority by the government to control, to regulate human conduct, human behavior, and to maintain law and order in society. So, what are the purpose of creating laws? So, the first important purpose to why the law is created is to create and protect individual rights and freedoms. This is the main purpose of creating laws, so that individuals' rights and freedoms are protected. Next, if there are disputes between individuals or entities, then that can be resolved by use of laws. Justice, fairness, and accountability can be ensured by implementation of just and fair laws. The framework is provided by laws. Laws provide a framework for the society to function, for governance of the society. So these are the main important purposes of law. Laws are codified. Codified means they are put under or put inside the statutes, the regulations, the acts, and judicial decisions. And these laws are binding. This is a very important part which says that all laws are binding on all members of the society. For example, IPC defines criminal offenses and their punishments also. So basically, these are laws inside the Indian Penal Code which defines the criminal offenses and their punishments, while the Constitution of India establishes fundamental rights and duties. Now, let's go on to the second question. What are rules and how do they differ from laws? So, these are all questions module wise and subtopic wise. So, what are rules and how do they differ from laws? Rules are specific directives or guidelines that govern behavior within a particular context. Very important to understand the distinction between rules, policies, guidelines. Rules, regulations, policies, guidelines, and so on, which we saw in the earlier first part of the video. So, rules are nothing but these are very specific directions or guidelines, that is, procedures which will control, which will govern the behavior of individuals or groups under a particular context. So, for example, motor vehicle act, and there are rules inside that motor vehicle act. So those rules are specific directions, or they are guiding as to control the behavior while driving. So that for that purpose, for industrial acts, if there are some industrial acts, so then that will those rules under that act will be specific to that particular context, to that particular situation, and these rules are often in detail, they're explained, given in detail and enforceable, but differ from laws in the following ways. Rules are not laws, rules are directives, and laws are rules, but rules are not laws. You have to understand this distinction. Now, how do they differ? How do rules and laws differ? We said laws come first, and laws are system of rules. So many rules make up laws. That is how we have to understand. So let's understand first the scope of law and scope of rules. What is its scope? Where does it apply? So basically rules are narrower in scope compared to laws. Laws are broader and more comprehensive. This we know because rules come under the laws, and we saw the definition of law. We saw the definition of law as law is a system of rules established, created, enforced by governing authority to control, regulate the behavior of individuals or groups in a society. And these laws are enforceable, they are justifiable. Okay, so therefore rules are narrower in scope compared to laws, and laws are broader and more comprehensive. Now let us look at the authority of rule and authority of law. Rules may be created by institutions, organizations, or regulatory bodies, but laws are only created by legislative bodies like parliament or state legislatures. This is the core difference between laws and rules. Rules anybody can create, any organization can create, companies can create, schools can create, colleges can create rules, but laws cannot be created by colleges, schools, and so on. Laws can be only enacted by legislative bodies like parliament or state legislatures, and they are enforceable also by the executive, by the legislature, and by the judiciary, that is, by the governing body, which is the government of India. Now, what is the purpose of rule and what is the purpose of law? The rules provide clarity and structure for implementing the laws. So we create laws and then we say how are these laws going to be implemented? How are these laws going to be enforced? So that is done by set of rules. Now these rules, they provide clarity and the structure as to how those laws will be implemented. For example, we have Indian Penal Code, so that is law. Now, under Indian Penal Code, there are rules, sections, regulations, and these rules provide clarity. For example, if such and such crime happens, then such and such punishment, this procedure, entire structure is there. it gives detailed clarity as to what needs to be done in what context, what situation. Now, an example, traffic rules, these are rules, traffic rules are there, specify how road users must behave under the framework of transportation law, that is Motor Vehicle Act. Under Motor Vehicle Act, that is the law. Now, under that law, there are traffic rules which needs to be followed. That is why we say rules are narrower, whereas laws are broader. Because for every violation there is rules, so it is narrow, it is concerned only with that specific act or omission of that act. That is why rules are narrower and laws are broader. Another example we have workplace safety rules. These outline the procedures to prevent accidents, ensuring compliance with labor laws. Now we have labor laws. Now inside these labor laws we have safety rules for the workplace, or for example, there is a building construction happening, so there are labor laws which needs to be implemented at that place for the safety of the workers, to prevent accidents and so on. Now, third question, define regulations and explain their relationship with laws. Now, in the earlier video, we had done these three definitions, but in a shorter version, uh, because that was a quick part of the video. Now, here we are going into detailed explanation of each of the topic covered under module 1 to 4. So, what is a regulation? Up till now, we covered what is law, what is rule, and now we are looking at what is regulation and how does it uh, compare with laws. So what is the distinction feature between laws and regulations? So regulations are formalized rules created by government agencies or authorities to implement and enforce laws. Now, first laws are created, then rules are framed under that law for better clarity and structure for their enforcement. Now, there is a regulation, they are regulated, meaning they are controlled, how they will be implemented, who will create it, how they will be enforced. That is regulation. So, regulate, the word regulate itself means to control. So, regulations are formalized rules created by the government agencies or authorities to implement and enforce laws. Implement and enforce. Implement means to create, and to implement, to enforce. Regulations have legal force and must comply with statutory provisions. They have regulations have legal force. That is, if regulations are not followed, then legal force or legal action can be taken on the individuals. Now, what are the key characteristics of regulations? Specificity, which means regulations provide detailed instructions on how laws should be applied. So rules were basically nothing but they provide clarity and structure. Rules provide clarity and structure. Rules were directives or guidelines that govern behavior within a particular context. Now, rules are traffic rules or workplace safety rules and so on. And rules are narrower, whereas now we are going into regulations. So regulations are detailed instructions on how laws should be applied. So we have regulations under each law. They are enforceable. Violations of regulations can result in penalties, fines, or either legal and other legal consequences. Regulations can be updated more frequently than laws to adapt to the changing circumstances. So, laws are not flexible, laws are rigid, but regulations inside these laws, what are regulations? Are nothing but formalized rules, rules that are formalized. And what is rule? Rules are directives or guidelines created by government agencies or authorities. Even regulations are created by government agencies and authorities. But there is a very subtle, very small distinction between all three of them. So first we have laws, then inside these laws we have system of rules, and then we have regulations which are formalized rules, means those rules are enforceable, those are legally enforceable. That is what it means. This is a very thin distinction. Now let us look at an example of regulation. So we have Reserve Bank of India, which issues banking regulations under the Banking Regulation Act of 1949. So there's a Banking Regulation Act of 1949 which is controlled, and the authority of that act is the Reserve Bank of India, RBI. This regulations under this act ensures financial stability and consumer protection. So I hope this is clear. Let's move on to the next one. What is a policy and how does it differ from laws and regulations? So up till now what I've understood is law is at the highest pedestal, is highest. Thereafter comes regulations which are more powerful, it is enforceable basically. Rules can be specific to a particular act, or it could be specific to an organization. It may or may not be enforceable, but regulations are enforceable. So first is law, then regulation, then rules. All right. So now we are looking at what is a policy and how does it differ from laws and regulations. A policy is a broad statement of intent. That is, we are intending something to do for which we have come out with a policy. It is a statement. Policy is nothing but a statement, or it is a guidance. It is very similar to rules. It is also issued by governments. It can be issued by organizations, institutions like colleges. Colleges can have their own policies. Schools can have their own policies. Even a housing society can have its policy. So policies are almost very similar in nature to rules, but they are more broader, whereas rules are more narrower, because rules apply only to specific context, specific situation. Now, it is a broad statement of intent. That is what you want, what you are desiring, or what is your intention. Or it could be guidance issued by the governments, organizations, institutions to achieve specific objectives, similar to rules only. Rules are also very specific to specific context. Unlike laws and regulations, now we are going into the distinction part. How does it differ? So policies are not legally binding, not always legally binding unless it is incorporated into the laws or regulations. So now we understand that policies may or may not be legally binding unless and until there are laws which state that these policies are a part of the law or are a part of the regulation. Then they will be enforceable, legally binding. Now, what is the purpose of policy? What is the purpose of law and regulation? So policies are set goals and priorities. Basically, policies are nothing but they provide your intention. They show your intention of what you want to do, or where you want to do, or what you're planning to do. So basically, it is a set of goals or priorities influencing decision making or resource allocation. So basically, you can create a policy that car parking policy, for example, in a housing society, or policy for distribution of food grains by the government. So then that will influence that decision. The car parking policy will influence the car parking decision in the society. And for the broader context, in the sense of the nation or the state or the uh, district or whatever it may be, to the country or the government, then that allocation of resources can take place according to the policy. So basically, first, government will come out with policies, and from that policies they will come, they will make laws, then regulations. So in this case, if you see, then policy is at the highest position, because first policies are created, under needs are understood, what requirements are there. This we have learned in economics in our first semester. So policies are drafted, and goals are set, priorities are set, and that will influence the decision making process. Laws will be created, resources will be allocated according to the policies, but it may or may not be enforceable or legally binding unless and until it is in the statute or act or regulation. Now, how is it implemented? So, policies guide the development of rules, which we already spoke about, and regulations to achieve desired outcomes. They may not, policies may not guide lawmaking. It can, but normally policies are guiding force for the developments of rules, like how will the food grain be distributed, or how will the resources be distributed, or what kind of uh, 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 financial rules will be implemented as per RBI, and all of that. So that is policy. Now these policies are created for or to achieve desired outcomes. Now let's take an example. We have India's National Education Policy (NEP) 2020, under which we all are studying right now. These policy of NEP, that is National Education Policy of 2020, outlines strategies, goals, outcomes for reforming the education system, for changing their education system. But it relies on laws and regulations to implement its recommendation. So policy may or may not be implemented or may not be legally binding. But through these policies, rules and regulations are created for the implementation of that policy. Next, why is it important to distinguish between laws, rules, regulations, and policies? Now, each of these play a specific role, and their application is also specific where they will be applied. Now, let's look at hierarchy that I was talking about in the previous question. So, laws form the foundation. First, laws will come, while rules, regulations, and policies operationalize them. That is, operationalize means enforcement. So, they can be enforced, they can be forced upon people to implement. So, they are followed by the people, by the citizens. So, what is their hierarchy? Laws form the foundation, while rules, regulations, and policies operationalize them. Next, compliance. Individuals, organizations must comply with laws and regulations, but policies may influence voluntary actions. That is, policies is not, it's just a guideline. It's not a directive, just a guideline. So the organizations and individuals may voluntarily act on those policies or may not, until and unless it is legally binding under laws and regulations. So this is compliance part. Next is the accountability. Legal consequences arise only from violations of laws and regulations, not policies. So there is a clear distinction. If somebody is not following policies, then it does not constitute any legal consequences. Whereas if laws and regulations are not adhered to, are not followed, then they will amount to violation of those laws and regulations. Let's take an example. For instance, if somebody violates environmental laws, which leads to pollution in the environment, then that will lead to prosecution, while failing to adhere to corporate social responsibility CSR policies. Now, each company, what is CSR? We must have learned in economics this part CSR. Each company is bound to reserve or keep aside certain portion. I am not very sure. I think it is 5% of the profits, if I'm not mistaken, 5 or 10% of the profits as corporate social responsibility. That is, they have to use that money out of the profit towards betterment of the society, towards taking up different causes in the society, maybe for children education, or maybe development of a park, or whatever they want out of that money. So these policies are there. They have to use that money, but where they want to use it, it's up to them. So these policies for the corporate, even if they don't adhere to it, even if they don't follow it, it will not attract legal penalties until and unless they don't reserve it. They have to, that is mandatory. But how they use it, where they want to use it, that is up to them. That will not attract legal penalties. Next, how do laws, rules, regulations, and policies interact in governance? Now, we saw what is the distinctive feature of those and how they differ from each other. Now, we'll learn about how they come together in governing, that is, in the governance of a country, in a governance of the laws, in the implementation of the laws. Now, these elements, that is, the laws, rules, regulations, and policies, they work together to create an effective governance framework. Now, laws, how do they help in governance? So, they establish overarching principles. That is, overarching means a mandatory kind of nature. So, the principles and obligations have to be mandatorily followed by the citizens. So, laws establish principles and obligations on the citizens, but rules, they provide specific instruction for compliance. Rules provide specific instructions for compliance. Compliance means to follow. Regulations ensure consistent enforcement of laws. Once regulations comes in, then laws will be enforced consistently. And policies, they set long-term goals and strategic directions. Now let us understand this with an example. So we have the Right to Information Act 2005, RTI Act. This is a law. Right to Information Act is a law. It mandates transparency in governance. The Central Information Commission issues regulations to standardize RTI processes. Now, how do we understand in this RTI example is that RTI is a law. Now, there are regulations in this Right to Information Act which are basically these are process, these are rules. Now these rules are made, these rules and regulations are standardized, are made by Central Information Commission, while government policies promote proactive disclosure of information. Now government has come out with policies in this case which states that each public information officer PIO has to disclose information as required by the citizen, except under certain, there are always exceptions. So under those exceptions, other than those exceptions, the information has to be disclosed. Now this is in the policies of the government. So this is how we can understand the distinction and how they come together for the governance. Next. Okay, let's look at few examples of laws, rules, regulations and policies in real life scenarios. Okay, let's look at the road safety. So for road safety, we have laws. The law is the Motor Vehicle Act of 1988, which governs vehicular operations and traffic management. So Motor Vehicle Act of 1988. Now, in this Motor Vehicle Act of 1988, there are rules. That is, rules are for speed limits, lane discipline. These are specified in the traffic rules. These are the rules. Regulations. How do we see regulations in the Motor Vehicle Act? So the Ministry of Road Transport and Highways issues regulations mandating seat belt use and helmet wearing. So these are regulations, and as we saw earlier in the regulation part, these are more flexible, whereas laws are rigid. So Ministry of Road Transport and Highways can come out with new regulations for mandating different things. For in this matter, in this case, we have regulations for seat belt use and helmet wearing. Now, policy. The government's vision of zero policy, that is zero policy means to aim, that is the aim of this policy is to eliminate road fatalities, that is road accidents, by improving infrastructure and promoting safe driving practices. So this is the policy of the government. It is broad in nature. It is a long-term vision. It guides framing of rules and regulations. So this is how we have understood the distinction and also how they work together, these four terms, which are law, rules, regulations and policies. Now each element plays a very distinct, separate yet interconnected roles in ensuring road safety. Now, what happens when there is a conflict between laws, rules, regulations or policies? What kind of situation is created in this conflict? So, laws will always prevail. Law is in the hierarchy, law is topmost. Law comes first. So, statutory laws, that is laws created by the statute, that is the parliament, by the state legislation. These laws take precedence. Precedence means priority over subordinate rules. Rules means the rules always come inside of laws. They are below the laws. Laws, regulations and policies come under the laws. So they are known as subordinate, below the laws. So statutory laws always will take precedence over subordinate rules, regulations or policies. Next, judicial interpretation. Courts resolve ambiguities, confusion or lack of clarity or inconsistencies, prioritizing higher level legislation. Now, if still there is a conflict, then the courts will interpret those laws to resolve any ambiguity between laws, rules, regulations and policies. But they will still, judicial interpretation will still prioritize higher level legislation. If the laws are there, then they will see that the laws are given higher priority through amendments. If there is a conflict, there is a third option of amendments. Conflicting rules, if there are two rules under two different laws or two different acts, or there are regulations which are conflicting in nature, then they may be amended, changed, or aligned with the laws, the present laws. So, this is how we resolve the conflicts between laws, rules, regulations, or policies. So, the first way of resolving the conflict is by way of laws. That is, laws will take higher priority, it will take higher precedence over the subordinate rules, regulations, or policies. Judicial interpretation, that is, court will try to resolve this conflict between laws and rules and regulations, and it will try to remove the ambiguity, the differences, the inconsistencies, the problems of the conflict by prioritizing higher level legislation. And finally, through amendment, the conflicting rules or regulations can be amended or may be amended, may be changed to align with the existing laws. Now, let's take an example. If a local municipal rule conflicts with national environmental laws, the latter will override, that is, the national environmental laws. The municipal rules will have no value. Municipal rules, if it is going against the national environmental laws, then the national environmental laws will override, will take higher precedence due to its superior legal status. Acts, laws are at the top of the hierarchy. So, I hope this is clear. Let's move on to the next one. How do laws, rules, regulations, and policies evolve over time? These elements evolve in response to societal changes. Laws will be created as per the need of the society. As societies change, societies have become more and more modern. New external influences, Western culture, Western influences have taken place. So new laws will come up, like we have Information Technology Act of 2000. So that has come in 2000. Then we have different acts which have come up as per the needs of the society. Now, not as only as per the needs of the society, but technological advancement, like laws related with information technology that we just mentioned, and emerging challenges like cyber security and all of that, and many more. Now, laws amended through legislative processes. Laws are always created and enforced. Basically, they are created by the legislature or the legislative, and they are amended. Laws can be amended also through legislative processes to address new issues. You don't need to discard the entire act or entire law completely, but we can bring in, the legislative can bring in amendments, can bring in changes. For example, there was an amendment in the IT Act to tackle cybercrime. So when cybercrimes increased, then additional amendments, additional regulations came into the IT Act. Next is rules. Updated regularly. Rules are very flexible, whereas laws are rigid, but amendments can be done in them. So rules are updated regularly to reflect practical needs and innovation, whereas regulations are revised to incorporate findings or international standards. So this is almost the same. Whatever needs are required. For example, we saw regulations in Motor Vehicle Act for seat belts, wearing of seat belts and helmets. So similarly, these can be revised and incorporated in the act, in the laws. Policies can be revisited or can be looked into periodically in a time bound manner to align with current priorities. So all of these will change as per the need of the society or the technological advancement and so on. Or as per the public demand, the policies can be created. Now let's take an example. Data protection policies worldwide have evolved into comprehensive laws like the GDPR that we saw in the earlier questions. So there was GDPR and there was one more IJVN for the uh, jurisdiction of internet. That I am not sure about the actual word. We'll check up when we come to that part as well in this video, or we can revisit that video for that authority uh, which is established for international enforcement of international laws. So GDPR is used in Europe. So next question is, what role do citizens play in shaping laws, rules, regulations and policies? All right. So citizens contribute to shaping these frameworks, that is frameworks of laws, rules, regulations and policies through, of course, participation. They will participate. They will engage in public consultation. So anytime the government comes out with new laws or regulations, they will first float, they will remove that policy, they'll put it into public domain for engagement by the public. They will ask the public to engage in consultation. They will ask the public to give their suggestions before enacting those laws, and debates around that policy formulation will also take place. So this is how the citizens contribute. It is not that the government just comes up one fine day, wakes up one fine day and makes a law. It is not like that. So first the framework of that law is floated, is given, is shown to the public, is open to the public for scrutiny, for consultation, for debate, and the suggestions, the ideas of the public are taken on board for implementation or for changes as and when required, or whatever is required. Next is advocacy, raising awareness about issues requiring legal intervention. So if laws are created, those can still be challenged by going to the courts and filing PILs, public interest litigations. So citizens also contribute to shaping these frameworks, that is laws, rules, regulations. So we had the uh, we had many uh, for the voting. We had contribution from the public. What was it called? I don't remember the exact. Electoral bonds, yes, electoral bonds. So electoral bonds were considered as illegal, and therefore they were discarded by the Supreme Court. So public citizens can go to the Supreme Court also. Next is through feedback. It highlights gaps or inefficiencies in existing rules and regulations. So government can also ask for public feedback. First, they will engage, participate, they will advocate, that is, raise awareness about issues requiring legal intervention. Then there will be feedback, that is, if there are certain rules or inefficiencies or gaps in the rules and regulations, then feedback can be asked. Citizens can give the feedback. And litigation, that is, challenging unconstitutional laws or arbitrary regulations in courts. This is the most important, where even if the government comes out with laws which are unjust, they can be challenged through litigation in if they are unconstitutional or they are arbitrary regulations, then they can be challenged and in the courts basically. Let's take an example. Now, women's safety, advocating the movements, the procedure, the things required to for women's safety, the things required from the policy end, from the government's end, from the enforcement end. This influenced the advocating of women's safety influenced stricter anti-rape laws and policies, as well as stricter work safety rules in India. So these are the grassroots movements. These have come from the very basic foundation as per the need of the society. Now, what are the primary sources of law? Let us look at some of the more grassroots movements of related with women's safety also. Let's look at few of the important acts related to women's safety which have come out from grassroots levels. First is the Protection of Women from Domestic Violence Act of 2005. What was the purpose? We'll go through this very quickly. It provides protection to women from physical, emotional, sexual, verbal, and economic abuse in domestic relationships. What was its relevance? It helps women at home in rural and urban settings access protection orders, shelter, and legal aid. Who are the authorities involved in this? There are protection officers, NGOs, local police. They will all help the woman under the Protection of Women from Domestic Violence Act of 2005. Now, there is another act called the Prohibition of Child Marriage Act of 2006. What was the purpose? It was to prevent child marriages, especially for girls under 18. It was very relevant in rural areas where early marriage is still practiced. It enables local authorities, when this act came, then it automatically enabled or local authorities could stop child marriages from and protect child brides. The third act was the Sexual Harassment of Women at Workplace, which is the Prevention, Prohibition and Redressal Act of 2013. This is the latest act almost. What was the purpose? It was for protecting women from sexual harassment at work, including unorganized sectors also. Not only organized but unorganized sectors also, and domestic workers also. They are also included in this. Now, it covers Anganwadi workers, ASHA workers, and female laborers. What are its key features? Formation of internal complaint committee or local complaint committees at district levels. Now, next was the Immoral Traffic Prevention Act of 19. This is a very old act, 1956. It was to prevent trafficking and sexual exploitation of women and girls. Protects vulnerable women and children from rural areas, especially from poor areas. The Dowry Prohibition Act. What was the purpose? Prohibits giving or taking of dowry in marriages. This is a 1961 act. The grassroots relevance of this is that it was important in areas, especially rural, even in urban areas also, where dowry practices still lead to harassment or violence against women or brides. Next is the POXCO Act, which is also very famous act, the Protection of Children from Sexual Offences. That was a 2012 act. It protects the minors under the age of 18 from sexual abuse and exploitation. It is a strong tool for village schools, Anganwadis, and child welfare officers to report and act against abuses. The Muslim Women Protection of Rights on Marriage Act 2019. This is a new act which BJP government has come out with. What is its purpose? This is the latest act, so this is a very relevant act. It declares instant triple talaq-e-biddat as illegal. Previously, any man would say talaq, 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 and the divorce would happen. But now that has been declared as illegal, which is also known as talaq-e-biddat, BIDDAT. Now, this act, this rules, regulations under this, it protects Muslim women from arbitrary divorce and ensures legal remedy. This is very correct. That was an arbitrary divorce, random divorce. Next was the Maternity Benefit Act of 1961, which was further amended in 2017. Its purpose was to provide maternity leave, job security, and health benefits. It extended to include women in contractual as well as unorganized sectors like agricultural workers, factory laborers, etc. But now, how much of this is actually implementable as far as unorganized sectors are concerned? Nobody from a factory laborer would get a paid leave if they are pregnant or they want to take a maternity leave. So I don't know how much it is enforceable or implementable. So this is all that these are the few acts that we went through. Now let's move on to the next topic, that is the primary sources of law. We are on page number 28 of 102 pages. So this is quite a long video. I suppose more than 4-5 hours of video it will be. Maybe I'll create it in multiple parts. If you bear with the long explanations and discussions, that is. The primary sources of law are we have already covered these in the previous video in short basically, but here we are going into much more detailed, more in depth. So the primary sources of law are the origins from which legal rules and principles derive their authority. Now, how would the law have that power? So there has to be some base for that. Now, these laws have come from customs. They have come from long standing practices accepted as legally binding within a community. Okay, so then they have got converted into laws. For example, the Hindu customs of marriage. So it's a custom. They have been followed for many years. Now, therefore, in Hindus, it has been decided it is a custom that only there won't be polygamy. That is, not more than one marriage. There is only one partner. Now that has come into law as a law, Hindu Marriage Act, Hindu Personal Marriage Law. So we'll look at a few examples of this. So these legal rules and principles that we have today, they get their authority from customs, okay, from treaties, from legislation, and from precedent. These are the four ways that the legal rules, the law gets their power, gets their authority, their enforcement. So let's start with custom. These are long standing practices accepted as legally binding within a community. Next is the treaty. Treaty is nothing but agreements between two sovereign states, two or more sovereign states, that is, two or more independent states, or also between international organizations which create binding obligation. It's very important. Any agreement has to create some kind of legal binding obligation. So these are known as treaties, Treaties, or treaty, Trety. Third is the legislation. That is the laws which are created by the legislative bodies such as parliament or state legislatures. Fourth is the precedent. Precedent is judicial decision. That is the decisions or orders given by the court, by the judges. These are judicial decisions, and they also are an act. They are also a source of law. From there also we get laws. Laws are created from there also. So these are judicial decisions that serve as authoritative interpretation of the law. That is, for example, if a judicial decision was given in a particular case, that will become a source of law. It will be interpreted, it will have an authoritative power of the law. So each source plays a distinct role in shaping the legal system and ensuring justice. Now let us look at few examples of this. Right, let's look at the customary law, that is the customs. Customs are nothing but long standing practices accepted as legal rules in a community. Now, let's look at few examples of that. Hindu joint family system under Hindu law. Under Hindu law, this has been practiced from centuries. Customary tribal land ownership in northeast India. Usage of dowry. Although now illegal, it was once a customary practice. Judicial precedent, case law. Law developed through judgment of courts. The principle of stare decisis, S-T-A-R-E decisis, D-E-C-I-S-I-S. Let the decision stand. This is a very important Latin maxim that we need to remember. Stare, S-T-A-R-E, stare decisis, which means let the decision stand. Now, the laws which are developed through or laws which are interpreted through judgments of the court or interpreted by the judiciary and which become the judgments of the court, these are known as precedent or judicial precedent. These are also known as case laws. For example, Kesavananda Bharati versus State of Kerala 1973 established the basic structure doctrine. It became a source of law. Then Maneka Gandhi versus Union of India 1978 expanded Article 21 right to life. What was the case law of Maneka Gandhi versus Union of India? Was that Maneka Gandhi's passport was impounded, was taken away from her, and she was prohibited from traveling outside of India. She challenged this in the Supreme Court, and the Supreme Court interpreted that the Article 21 right to life and liberty has been violated and the due process of law has not been followed. Let us also quickly look at the judicial precedent, that is case laws. These are the laws developed through judgments of courts. The principle of stare decisis, let the decision stand. Few of the examples are Maneka Gandhi versus Union of India 1978, which expanded on the Article 21 right to life and liberty, and Kesavananda Bharati versus State of Kerala, establishing the basic structure doctrine. Now, the other source of law is through legislation, statute laws, laws made by the parliament or legislature. Examples are Indian Penal Code of 1860, IPC, which is also known as Substantive Criminal Law, Right to Information Act of 2005, and the Constitution of India 1950. We have constitutional laws. This is also source of law. The fundamental source of law lays down the structure of government and basic rights. So this is also known as the fundamental, the basic source of law. Article 14, right to equality. Article 21, right to life and personal liberty. Preamble of the constitutions. These are the sources of law. Conventions, that is political or international practices. Non-legal but accepted practices that influence legal development. Example, in India, the Prime Minister is always from the Lok Sabha, though not legally required. UK's constitutional conventions, that is royal assent is always granted. So not very sure about what it means, but let's skip that. It's not very important. We can even write just one example or skip the example also. International laws, these are also very important. Agreements and treaties between nations that influence domestic laws. Let's take an example. Universal Declaration of Human Rights. India uses it to interpret fundamental rights. Convention on Elimination of All Forms of Discrimination against Women affects gender laws in India. Personal laws and religious laws. Laws based on religious scriptures applicable to specific communities. For example, Hindu Marriage Act of 1955, Muslim Personal Law, Shariat, Application Act 1937, Christian Marriage Act of 1872. These are all different examples of sources of law. Next, let's look at how do customs become a source of law. Customs become a source of law when they meet specific criteria. So this also is a very important question. This can also come in the exam. Antiquity. The practice, antiquity means long standing continuous practice. The practice must have existed for a long period, demonstrating continuity, reasonableness. It should align with principles of justice and fairness. Consistency. The custom must be uniformly followed without significant deviation. First of all, it should have been existing for a long time and it should have been followed for a long time without any substantial deviation or changes. Recognition. It must be acknowledged and accepted by the community as having legal force. All of these four are very important to understand why customs become a source of law. For example, in India, customary laws govern personal matters like marriage and inheritance among certain communities, provided they do not conflict with statutory laws. Next, what role do treaties play as a source of law? Treaties are agreements between nations or international entities that establish binding obligations under international law. They influence domestic laws in two ways, through incorporation or through transformation. Incorporation means it is directly applicable without additional legislation, which is rare in India. It doesn't happen. It happens through transformation only, which is it is implemented through enabling legislation passed by the legislature. For instance, let's look at India's ratification of the Paris Climate Agreement led to amendments in environmental laws to comply with global emission targets. This is very important. So, India uses transformation transformation laws to implement the treaties. So treaties are enabled through the process of transformation. That is, the legislation will pass these acts in the parliament. Explain the process of legislation as a source of law. Legislation refers to laws created by legislative bodies through a formal process. First, proposal. A bill is introduced in the legislature, example Lok Sabha or Rajya Sabha in India. Debate and scrutiny. Members will discuss, analyze, suggest amendments. Approval. Both houses will pass the bill after voting. The president will sign the bill into new law and give its assent, that is, its permission. The statute is published in the official gazette and it becomes enforceable through publication. So, this is the process of how the laws come into effect through the process of legislation. That is, first a bill is proposed, it is debated and it is scrutinized, then it is approved by both the houses, then the president gives its assent, and finally it is published in the official gazette. Example include the Indian Penal Code IPC and the Information Technology Act of 2000. What is precedent and how does it function as a source of law? Precedent, also known as case law or stare decisis. That is, stare decisis, what was the Latin maxim of this? Let the decision stand. Refers to judicial decisions that serve as binding interpretation of the law. Key features include ratio decidendi, and obiter dicta. Ratio decidendi means the legal principle underlying the decision which lower courts must follow. And obiter dicta means observations made by the judges that are not binding but may influence future cases. So ratio decidendi means the legal principle underlying the decision. For example, the Supreme Court's ruling in Kesavananda Bharati versus State of Kerala 1973 established the basic structure doctrine which remains a cornerstone of constitutional law. How do customs differ from treaties and legislation? Customs, treaties, and legislation differ in origin, scope, and enforcement. Origin. Customs arise organically from societal practices, while treaties result from diplomatic negotiations and legislation stems from deliberate legislative action. Customs, the scope of custom is localized and informal, whereas treaties and legislations have broader applicability. Customs lack codification, enforcement unless recognized by the courts, while treaties and legislations are formally documented and enforceable. For instance, customary land ownership practices coexist with statutory property laws in rural areas. Provide an example of a treaty influencing Indian laws. The United Nations Convention on the Rights of the Child significantly influenced Indian legislation. Ratified in 1992, it inspired reforms like the Juvenile Justice Care and Protection of Children Act 2015. Provision on child rights, protection and welfare were incorporated into national policies and programs. This demonstrates how treaties shape domestic laws to align with international standards. Why is precedent considered a reliable source of law? Precedent ensures consistency, predictability, and fairness in the legal system. Consistency because courts resolve similar cases uniformly, avoiding arbitrary outcomes. Predictability means individuals can anticipate legal consequences based on past decisions. Fairness means binding precedent prevent bias and ensure equal treatment under the law. This is fairness. Binding precedents prevent bias and ensure equal treatment under the law. For example, the landmark judgment in Vishaka versus State of Rajasthan 1997 set guidelines for workplace sexual harassment, guiding subsequent rulings. How does legislation interact with other sources of law? Legislation interacts with other sources in various ways. Customs. Statutes may codify customs, that is, statutes means legislation, may codify customs to give them legal recognition. The example, Hindu Marriage Act of 1955. Treaties. Legislation implements treaty obligations domestically through transformation process. Example, environmental laws align with international agreements, that is the Paris and Treaty. Precedent. Courts interpret statutes, creating binding precedents that guide future applications. For instance, the Right to Information Act 2005 was shaped by public demands and judicial pronouncements emphasizing transparency.